Welcome to the FedLife podcast with Dan Sipe from Serving Those Who Serve. In this podcast, Dan draws from years of financial experience to help federal employees overcome challenges that every Fed can relate to. Join us for this journey as we reach, teach, and serve to help you make the right financial decisions. Now, on to the show.
Hello and welcome to this episode of the FedLife podcast. I am your host, Dan Sipe. Additionally, as you, my regular listeners know, I'm the branch manager here at Serving Those Who Serve and Lee Sipe and Associates. And I will begin, as I always do, by saying thank you. Thank you for taking the time to listen, and thank you for your service to the country, to me, to everyone. You don't hear that enough. You will always hear it here. As you might guess, Ed Zurndorfer is back with us again today. The Guru is here as part of our ongoing mission to reach, teach, and serve you. At the outset, I need to say the opinions of our guest, Ed Zurndorfer, are not the opinions of Raymond James or Serving Those Who Serve, and this podcast is presented for information only and is not intended to be taken as advice. All listeners should consult their personal advisors before taking any action. And if you do not have a personal advisor, hit us up at Serving Those Who Serve. That's stwserve.com. We will help you any way we can. If you're a regular listener, you know once again that we always try to follow Ed's FedZone articles. Gives us one more way to reach and teach. If you are new, let me tell you about yet another way, and that is the weekly serving. Every week, we will deliver the best of Ed, Jen Meyer, Benefits Ben, and yours truly, right to your inbox. Don't miss out. See our subscription information on the YouTube page for this podcast. Well, Ed, we are digging into a topic that I think a lot of Feds may not think about, and that's estate planning. So I can almost hear listeners saying to themselves right now, Dan, Ed, I'm not a multimillionaire. What's the big deal? So Ed, what's the big deal?
Well, Dan, I have to tell you up front, and it's very important I mention this about estate planning. Two things
Sure.
I have to mention up front. Number one, I'm not a lawyer.
Okay.
I am not giving out any legal advice today.
Absolutely.
But what I hope to do is to inform our listeners what they need from a lawyer, in particular an estate planning lawyer, in order to get a proper estate plan. That's the first thing I want to say. Second thing I have to say is that estate planning is not just, quote unquote, for the rich people. There's more to an estate plan than just a dollar amount. What I mean by that is, for the example, that if an individual, God forbid, is on life support, and a decision has to be made as far as any medical procedures or medicine, anything, the hospital, the doctor does not ask the family, now, what is the actual net worth of this person? Is it really worth going through all this hassle? I mean, if they're not a rich people, why do we want to keep this person alive? Absolutely not. Decisions have to be made in terms of medical procedures, medication, and that has nothing to do with money. So what I'm saying is everybody needs an estate plan, because there are different parts of the estate plan, one of which has nothing to do with money, deals with medical procedures, which I hope to talk about today.
No, that makes sense. That makes sense. And you begin with an interesting idea in your article, and that is that there's been an uptick among younger folks for interest in this topic of laying out these types of plans, correct?
That is correct. And I think the reason for that is there are a couple reasons. Number one, I think now that COVID is officially 3 years old, when COVID started back in March 2020, back in those days when things were really bad, hospital emergency rooms were overwhelmed. There were no more hospital beds. And we saw this on the news, and we noticed that it's not just, quote unquote, old people that are suffering here, that they're on the verge of death. Young people. And these young people had no will. They had no living wills, no powers of attorney, nothing. And it sort of hit younger people. Gee, I have a family. I got a young family. What happens if I die? What's going to happen to my children? How will my family take care of themselves?
Sure.
So I better have something in writing. and there was a surge of interest among particularly younger people about the need to have an estate plan.
Gotcha. Well, that makes sense. So let's jump in. Your article addresses 6 specific topics. So let's just press ahead. And up first, as you just mentioned, would be wills. So what should we be thinking about and talking about there?
All right. So a will is a part of an estate plan. And essentially what the will is, it's called the last will and testament. It's a document which instructs actions or right or instructs the actions or rights of others over the decedent's property. When someone passes away, they own property, and everybody
Sure.
obviously owns property. We're not just talking about a sizable brokerage account. We're talking about you own a house, you own a car, you have personal items, jewelry, tools, a car.
Mm-hmm.
And talking about a house, a house that someone owns real estate. It might be their own personal residence. It could be a rental property. It could be a vacation home. The question is, what's going to happen to this property when someone passes away? Ideally, it'll be passed on to loved ones, but it's not automatic. The person that has to, who writes the will has to instruct how they want their property to be distributed. It's not an automatic thing unless they own the type of property in which they can name a beneficiary. We'll talk about that a little bit later. But I'll give you one example, Dan. Federal employees, they own the thrift savings plan. They put money into the thrift savings plan. They name a beneficiary. Federal employees, many of them have the federal government life insurance. They name a beneficiary in which they name the person or person who's going to get the whatever is left in the TSP. They'll get the beneficiaries will get the named beneficiaries will get the proceeds from the life insurance policy. But the point is that the person who the TSP participant, the FEGLI, the Federal Employee Group Life Insurance owner, designates that beneficiary, how the money will be distributed. But certain assets, ones I mentioned, personal items, your car, your house, real estate, you cannot name a beneficiary directly. So therefore, you have to name it as part of your will, or we'll talk about a little bit later, setting up what's called a living trust.
Sure. And you talk a little bit about something that, we know about in the work that we do, but nobody else may have encountered the term, and that's a holographic will. So this is not a will that floats out there and gives you an image of a will like a hologram. This is something else entirely. Tell us about
it. That's correct. A holographic will is a will that can be constructed. You can actually draw up your own will without using an estate attorney. Okay. But in order for the holographic will to be really legal in a sense, it has to have what's called 4 attributes. And they include, it has to be constructed in the handwriting or the person writing the will. Someone else cannot actually write it. And by the way, the person who writes the will is called the testator, like testator. Second, the will must indicate that the testator's intent to write the will. They have to state that specifically. It is my intent to write this will. Third, there should be a description of any property or an identification of beneficiaries in the will. Lastly, the will needs to include the testator's signature. It has to be signed, a legal signature by the testator. Okay.
Gotcha.
But I got to be very honest with you, Dan. I really question sometimes people who write their own wills, holographic wills. Mainly because, you might forget to dot some I's, cross some T's. And then if it's really not what I call what it should be, it's not legal, the whole work, all the work is for naught.
Sure.
And then the person will be considered to be died, without a will. And then it's going to be up to the state to decide who gets the deceased asset. So I always recommend that people always go to an estate attorney to get your will drawn up. Why? Because the I's are dotted, the T's are crossed, everything is done with attorney. But the person will say, but it's going to cost me. It's going to cost me. Well, of course it's going to cost you. You have, the estate attorney is doing a service, and the estate attorney has the background to do this. You have to pay this is a professional. You have to pay for it. And
Sure.
they're still complaining. Okay, well, how much is it going to cost me? It's going to cost. and I say, listen, most attorneys will charge for will depending on the size, the amount of your assets and so on, depending how organized you are when you bring your stuff to the attorney. Maybe anywhere from $500 to $1,000. And I just like to relate a story about one of my clients. This happened about 5 years ago. And she's a single person. She's still single. And she bought a house locally, and she paid for the house about $500,000. $500,000. And she came to me. She wanted to make sure that, before she went to settlement, that everything was what it's supposed to be. She did everything she needed to do to make sure the house would be bought properly. So I'm looking at her settlement, her settlement sheet estimate, what she'd have to pay at settlement as part of the closing costs. And I said, everything seems to be okay, but I think there's one thing missing. And she said, what's that? The cost of an attorney to check the title for the house. What do I need a real estate attorney for? I know what's going on. I know what I'm buying. After I've been approved for the processing, the mortgage company approved me. I said, you got to get that attorney to check to make sure that the title of the house, there's no infringements on the title. Give yourself peace of mind. And she said, how much is that going to cost me?
Oh, boy.
Here we go.
Yep.
And I said, I know a few real estate attorneys, and they charge anywhere from $500 to $700 for a closing, which includes checking out the title, make sure everything is proper. So she said to me, $500 to $700. That's a lot of money. I said to her, how much are you paying for the house? Oh, $500,000. $500,000, and you can afford those monthly payments, and you're not willing to fork out another $500 to give you peace of mind? She said, yeah, come to think of it, maybe you're right. Maybe you're right. And she did. Well, the same thing here, Dan, when it comes to the will.
Sure.
Forking out anywhere from $500 to $1,000 to give you peace of mind that the will that you're going to draw up is proper. Everything is what it should be, and there won't be any problems down the line. Please do that. I tell the person, don't do it yourself.
Yep. Couldn't agree with you more. So up next in your article, you go to the living will with advanced healthcare directives.
Oh, yes.
Tell our folks about that.
Well, Dan, once again, let's go back to COVID. This was a wake-up call.
Sure.
Wake-up call that individuals, and it has nothing to do with money now, as I was explaining a few moments ago, it has nothing to do with money. So let me explain what a living will and advanced healthcare directive, what that's all about. A living will and an advanced healthcare directive, also known as the advanced healthcare directive, also known as a healthcare power of attorney, will assist an individual so that the individual can give instructions and wishes in the event he or she is unable to voice medical decisions for himself or herself. Okay. This is often the case with a terminal disease or sudden incapacity caused by an accident or head injury. Many individuals feel strongly about not wanting to be kept alive or on costly life support. They don't want to be kept on this life support for extended periods of time because of the cost involved. I mean, this is their decision, Dan. And I got to emphasize, there is no right or wrong here. It's what the individual wants. Okay. The individual may feel if there's no chance of recovering. Okay. Why keep me on life support? It's a waste. Okay. So the person says, at a certain point, terminate me. Okay. Some individuals with the opinion that have the opinion that the decision to be left on life support should not be decided by others, and would prefer to be kept on life support and cared for even in a comatose state. That's their decision.
Gotcha.
But the point I'm trying to make, Dan, it's the individual's decision. You got to put it in writing. Just leaving it up for someone else to decide, like the state,
Sure.
that's not a good idea. And the problem there is going to be, there's going to be family problems.
Yep.
Some family member said, keep him or her on life support. Other family says, no, let's terminate it. Why do we have to be burdened with this? It's a horrible thought, burdened with this.
Absolutely.
So to avoid family problems, put it in writing as part of your estate plan.
Couldn't agree with you more. Having within my family, having been placed in the position of having to make that type of decision when there wasn't a clear advance directive, it is emotionally challenging, to say the least. So if you love your kids, put the healthcare directives in there, the living will. It's a great idea. Couldn't agree with you more, Ed.
And please, if we're talking about parents here, and I know many of our listeners have parents who are living there, getting up in age, please make sure that their parents, as well as themselves, of course, have this living will and advanced healthcare directive. And the parents will inform the children who is the agent, who's going to be making the decision. They shouldn't hide the fact that they have this documents. They should tell the children they have it, where it is, and all the details about it, so that children have no surprises.
Yep. And just so I stay on the right side of my compliance department, my earlier statement is my opinion, and it does not reflect the opinions of Raymond James, and it is not meant to be taken as advice. But having lived through it, that is my insight and opinion. Okay, so item number 3 has a scary name: power of attorney. So what are we doing here?
Well, we're going to talk about a financial power of attorney. We just talked about the power of attorney for healthcare. That's the Advanced Healthcare Directive. Now we're going to shift gears a little bit in terms of a financial power of attorney. It's also known as a durable power of attorney. Gotcha. What is a let's explain exactly what a power of attorney is. A power of attorney is a document in which the principal, the person who owns a financial asset, among other things, will appoint an agent, so that the agent has power over the principal's finances in the event the principal is unable to make financial decisions for himself or herself. Let's give an example. It's tax season, right, Dan?
Yep.
So we're all filing our taxes. Suppose somebody knows they have their taxes done, have to have their taxes prepared, but they're not able to do it. Something happens to them. So someone else prepares the taxes, and the individual has appointed someone to be have this financial power of attorney, who will be able to look over the tax return and, most importantly, be able to sign it. Sign the document. That's one example where a financial power of attorney would occur. Let me give you another example. And I want to take the example of someone who's single. Maybe several of our listeners are single individuals, and they're working, and they earn a good living, and they pay their bills. And my scenario is, what happens if this person gets very ill, gets into an accident, and cannot take care of their finances? They can't pay their bills. They can't pay their mortgage. They can't pay their rent. They can't pay their utility bills. who is going to pay those bills?
Good
Who?
question.
I assure you that the mortgage company is not going to have any sympathy on the person. I know it's a horrible statement, but they're not. They want that mortgage to be paid. There's no waiver of mortgage payment because you're unable to pay it. Okay. Well, here's what somebody said to me who was single one time, because I'll do it now. I was going to do it later, but here at Serving Those Who Serve, I know I always got to ask you if I could do this. We have one of our webinars. It's called Estate Planning.
Yes, it is.
Where we go through this, and we're going to actually have our next estate planning webinar. If you hear this in time, will be presented on March the 28th. So if you want to like to sign up for it, it's free. Please go to www.stwserve.com. www.stwserve.com. Go to webinars, and then you'll see the one that says estate planning. That one is held every 3 months. The next one will be held on March 28th. Well, someone asked me the question. Well, actually, one of my clients said to me, because during tax season, I usually talk about some of the clients ask me, what do I need? What do I have to do the rest of the year? I said, besides checking your withholding, but you should be looking at your finances in general. One of the things you need in an estate plan. And one client said to me, well, I think I have everything. I got a will. I said, do you have a financial power of attorney? And they said, no, I don't have a financial power. Why do I need a financial power of attorney? Well, for example, you can't pay your bills. You can't pay your bills because you get sick. You get into an accident. You're in the hospital for a long time. You're in no position to pay your bills. Who's going to take care of your finances? Well, that's a good point. But and the person came back a few days later and said, I got the solution to the problem, Ed. You see, I have an adult child, and I think what I'm going to do is I'm going to put my adult child's name on my account and make him a joint owner. So that anytime bills have to be paid, my child can pay those bills. Okay, take care of. In fact, I'll put my child on my brokerage account. Make him an owner of my brokerage account. I have this nice brokerage account, and I have stocks and bonds. I got a money market account, and this way, my child can take care of anything that needs to be taken care of in case I get incapacitated. I said there are a couple of problems with that. I told the person. Number one, if your child gets sued, guess what? Because your child's name is on that account as a 50% owner, that 50% of your accounts are fair game for the creditors and predators.
Sure.
Is your child married? Oh yeah, they're happily married. I said, I hope it continues. But guess what? If your child does get divorced because your child's name is on that account, on your account, 50% of your account is fair game for your spouse's soon-to-be ex-spouse.
Ouch.
Gee, I didn't know that. Well, guess what you do? So the person said, what am I going to do? So I said to the person, it's very simple. You go to the bank, credit union, brokerage, and they have a POA form that stands for power of attorney, in which you can put your child's name on as the agent for you. You're the principal. And what does that mean the child can do? They can sign checks. They can make transfers. They can make withdrawals. They can take money out on your behalf. And the person said, well, what's the difference between making my child as a power of attorney on account versus making a joint owner? It's very simple. They're not an owner of the account.
Right.
They're not. The account is not fair game for creditors and predators. It's not fair game for a soon-to-be ex-spouse because they are not an owner. That POA form that you signed, that you're signing, appointing your child as the agent, is only valid while you are living. Once you pass away, it is null and void.
Gotcha.
But there is no chance whatsoever that your child, if they get into trouble, get sued, get divorced, that money is not fair game. The only thing I got to tell you is I hope that child is very trustworthy and is not a spendthrift, is going to take the money out whenever they want to. Because the beauty of this financial power of attorney, the durable means that the agent can take the money out, can do anything on behalf of the principal without getting formal permission from the principal to do so. The whole idea here, Dan, of the durable is the fact that if the agent had to get permission from the principal to do whatever had to be done with the principal's finances, that defeats the whole purpose if the principal is incapacitated.
Makes sense.
So therefore, that's why it's always a financial power of attorney is always called a durable power of attorney. Now, I just want to say one thing. This has been my experience. I'm talking very general now. As part of your estate plan, you need to have a financial power of attorney drawn up by the attorney. The attorney has to do this. You can't do this on your own. The attorney has to do this.
Mm-hmm.
And the person will say, well, now I'm all set to go. I'm all set to go. The financial power of attorney will cover everything, all of my assets, whether it's my bank accounts, my brokerage accounts. Be careful. It's been my experience through the years in dealing with this, that most banks, most credit unions do not honor an attorney, a financial power of attorney drawn up by an attorney. They have their own form that has to be filled out.
Gotcha.
That's been my experience. So please do not think that you only need one financial power of attorney. You have, for every institution, you have money. Like I said, banks, credit unions, brokerages, please ask the institutions in terms of how do I draw up a power of attorney? Can I use the one I have as a general, or do you have your own specific application for financial power of attorney?
That makes sense. That makes sense. So Ed, your next one, I think is going to be a surprise to people to think about in terms of estate planning, and that is beneficiary designations.
Oh.
Because we just think about, oh yeah, I did that, but tell us more.
Let me just say in general that, and when it comes to estate planning, when it comes to settling one's estate, because it can be costly, the first thing individuals should do to minimize the cost of an estate settlement when someone passes away is to name a beneficiary for anything you can name a beneficiary for.
Mm-hmm.
And I'd like to go through the list here for federal employees.
Go ahead.
Who they can name beneficiaries for. I'm going to list all the particular items. And when it comes to federal, in terms of federal pension plans, life insurance, I'll even give the form number. The form.
Perfect.
I have a memory of forms from here.
Yep.
All right. So if you are a CSRS or a SERVS offset employee, or you could be retired, because it's not too late to draw up this form. Standard form SF2808 is entitled Designation of CSRS Contributions. What are we talking about? CSRS. When you're a CSRS employee like I was, every pay date, you're putting in 7% of your paycheck into the CSRS Retirement and Disability Fund.
Gotcha.
That money is put in with after-tax dollars. You get that money back after you retire. It's part of your monthly annuity until it's paid back in full. Okay. If you're a SARS offset employee, 0.8% of your paycheck goes into the CSO's retirement disability fund. Same thing. It is put in with every 2 weeks with after-tax dollars. You get it back as part of your monthly CSRS annuity until it's paid back. But what happens if it's not paid back? You die before your life expectancy. Then you name a beneficiary for those contributions on that form. Who can be named as beneficiary of those contributions? Anybody. It could be a spouse. It could be a child. If you're not married, it can be a niece, nephew. It could be a good friend. It could be a charity. But the point is, you should name a beneficiary, because I've seen this too often where someone died under CSRS because that's the older retirement system. People do die, that they never fill out the form SF2808, and they died before they got their money back. So who kept the money? U.S. government, when in fact they should have paid it out to somebody. Or maybe there's an order of precedence, but I really doubt that's going to happen. The government's going to end up keeping it. For FERS employees, same situation, except there's a different beneficiary form. It is standard form SF3102. Standard form SF3102. All the two forms, SF2808, SF3102, can be downloaded from www.opm.gov.
Yep.
Same situation. Just want to say one more thing about those contributions that are given back. If an individual is giving a survivor annuity, usually to a spouse, whatever the CSRS annuitant or FERS annuitant is getting back of their contributions each month, when they pass away, the same amount is given back as part of the survivor annuity until it's paid back. And then if anything's left over after the survivor annuitant dies, that money will be paid out via the beneficiary forms. Okay.
Gotcha.
Next, TSP. Everybody loves TSP.
Yes, we do.
Beneficiary form, TSP-3. Can be downloaded from www.tsp, www.tsp.gov. Maybe individuals did file the beneficiary form when they were first hired, let's say in the 80s, 90s, early 2000s, and they named, let's say, a spouse as beneficiary, but they have since divorced their spouse. Please update the beneficiary form. Please. Okay. Next, FedLife life insurance. Standard form SF2823. SF2823. Okay. If a federal employee owns individual life insurance, they bought it from a private company, the company has a beneficiary form. Please make sure it's filled out.
Gotcha.
Now, I mentioned about updating your beneficiary form, in terms of maybe your personal circumstances have changed since you initially filled out the beneficiary form. Like I gave divorce. I'd like to share a true story about FedLife in which someone did fill out the form SF2823, and they came into the government. This individual came into the government about the same time I did in the early 1970s, and was single. He was right out of college, 22 years old. So he filled out the form SF2823. And who does he name as his beneficiaries? Mom and dad. Each gets 50%. Makes sense. Well, he subsequently got married and had 3 children. He never updated his FedLife beneficiary form. His parents were still on there. He died in 2004 of a massive stroke at the age of 54. Who got $600,000 of FedLife life insurance, Dan?
That would be mom and dad if they were still around, but I have a hunch you're going to tell me more to the story.
Unfortunately, mom and dad had passed away. So what happened? the mom and dad's estate had to be reopened.
Oof.
His wife and 3 kids eventually got the FedLife insurance at a big cost, attorney fees, estate, settlement costs, things like that, because the estate had to be reopened, and a big delay. It was unnecessary. So got to make sure those beneficiary forms are updated.
Couldn't agree with you more.
Traditional IRAs. Roth IRAs. Yes, Roth IRAs need beneficiaries, and make sure they're up to date. Please. Next, bank accounts. Now, this might be a little shocker, Dan. Bank accounts, checking accounts, savings accounts, CDs. You mean I can name a beneficiary? Yes, you can. It's called POD, payable on death, POD. Go to the bank or credit union and ask them for an application for, a beneficiary application form. It's called POD. And why would you do that? Because this way, in your will, you don't have to name your bank accounts as as part of your estate. Didn't mention this, but one of the problems with a will is the fact that it has to go through probate. The probate process can be lengthy, and it can be costly.
Sure.
You want to try to avoid as much of the probate process as possible, and by having these beneficiary forms filled out, that's going to, again, lessen the amount of assets that will be subject to probate, and that does include bank accounts. If you have a brokerage account, like XYZ broker, Merrill Lynch, whatever, Vanguard,
Sure.
whatever, we're just naming a few here.
Mm-hmm.
They also have a beneficiary form.
Yep.
It's called a TOD, though, not POD.
Right.
It's called TOD, stands for transfer on death. Make sure that's filled out. Okay. So that's a list of the most common beneficiary forms that should be filled out. Talking about beneficiary forms, I have a recommendation that when you fill out your beneficiary forms, employees and retirees, you're naming primary beneficiaries.
Mm-hmm.
And you can name, most cases, as many as you want. You can have 10 beneficiaries, each getting 10%. But in addition to primary beneficiaries, name contingent beneficiaries. What's a contingent beneficiary? Contingent means that if the primary beneficiary dies, then the contingent beneficiary steps in. I've seen this too often, where someone named one primary beneficiary as the beneficiary of a particular asset, whether it was, I think it was life insurance.
Mm-hmm.
Well, guess what? The primary beneficiary predeceased the life insurance owner, the owner of the policy. Therefore, there was no beneficiary when the owner died. The person didn't update their beneficiary form, and when the primary beneficiary died. By naming contingent, you won't have that problem, because when the primary dies, the primary beneficiary dies, the contingent steps in automatically. So it's just a recommendation.
Yep. And this, folks, this is probably the point where if you're listening, you're going, ooh, so that's part of estate planning. Absolutely. And yes, it is. And so is this next one, guardianship of minor children. And I hope we have some young people listening that have minor kids. So Ed, talk to us about that.
Well, Dan, like I said, COVID was a wake-up call. A lot of young people felt, I don't have to worry about having a will. I got young kids, but I'm healthy, no problem. I'll be able to raise them, no problem. But COVID was a shocker. Okay. I mean, Let's face it, the chances that a young and likely married individual who has children, will not be around to raise his minor children are very small. But there's always that possibility.
Sure.
So it's very important that if you have minor children, I don't care if you're married, I don't care if you're single, divorced, widow, whatever it is. If you have children under the age of 18, you have to name guardians for your minor children. Name someone. You don't want the state to decide who's going to take care of your minor children. That's not the way to do it. It can be very costly. It's not what you really wanted.
Sure.
I know it's not something you like to think about. Okay. Untimely
Right.
death of a young person, but it's happening.
Yes, it does. Yes, it does. And that is a great point. And Ed, you round us out with your final point, which, no pun intended, is final arrangements. So what are we talking about here? What should people be thinking about?
Well, in order to ease the process for individuals' loved ones after an individual dies, it's really important to pre-plan what I call one's final arrangements. Okay. Granted, for many individuals, this is more difficult than any other aspect of estate planning. But by not planning for this in advance, it could result in individuals' final wishes not being carried out. Everything regarding one's final arrangements should be written down, signed by the individual, and notarized. For example, I'm going to give you an example. Maybe someone wants to be cremated. That should be right. That should be stated in writing. Maybe somebody insists on being buried. Fine. Okay. Maybe someone wants to donate organs. Okay. Everything should be stated in writing. What type of funeral they want. Do they want a chapel service? Do they want a graveside? Okay. Everything should be stated in its entirety. And ideally, the person will make arrangements financially to pay for the funeral. Don't leave it up to, their family to come up with the assets to pay for the funeral. I mean, some people say, well, I'll have money left over. They can just use the money in my account to pay a funeral. Not so quick, because the funeral will be within a few days of the person's death. They're not going to have access to that money for a while.
Sure.
So therefore, you need to do something. I'm sure you've heard these commercials on TV about these life insurance policies. These are prepaid funerals.
Mm-hmm.
But and they make advertisements. You can buy a $10,000 prepaid plan. It's a life insurance policy. It's a life insurance policy. That's all it is.
Yep.
So whatever it is, think about this. I tell individuals, think about, if God forbid you passed away, what needs to be done in terms of making arrangements for your funeral that is in line what you want. There is no right or wrong here. It's what you want. All I'm saying is, please put it in writing.
Great points, Ed. And this is a great article, folks. Even though you've listened today, head over to the Fed Zone. That's fed-zone.com. You'll see Ed's article. If you couldn't scribble fast enough to get all the forms, they're all right there. And Ed, this is great. And I know we're going to have some folks thinking differently about a term like estate planning, because again, geez, I'm not a rich person. Well, number one, you're richer than you think you are. You have more stuff than you think you are. You have more obligations than you think you do. So word to the wise, follow up with this with Ed.
That article, Dan, is, by the way, it's entitled "The Importance of Having a Estate Plan." It appeared it was the last column in February 2023. And and just one more plug again for our estate planning webinar, which will be held again on March 28th. We hold them every 3 months. So please, if you have not attended any type of estate planning webinar from anywhere, doesn't have to be ours, but anyway, it's a good idea to listen to it. You can ask some questions. You can ask questions. It's a 3-hour webinar. You'll really learn a lot. So please take full advantage of it. It's free. All you got to do is go to www.stwserve.com and sign up free. Thank you.
There you go. Ed, once again, I thank you for all that you do with us for the federal community, especially how you help our team. Folks, that is a wrap. We will catch you on the next podcast where we're talking taxes. It's that time of year, and taxes are near and dear to Brother Ed's heart, so we'll be digging into those. We are serving this to serve. Be sure to subscribe to this podcast on our YouTube channel and Spotify. Remember to share it with friends and strangers. Check us out on Twitter and LinkedIn. Do not forget those live webinars every week. Just like Ed said, stwserve.com. You will see the blue webinar button you hover on, turns red, click, it takes you to the whole gamut. The guru will come to you. reach you where you are, teach you where you are, serve you where you are. Sign up for one, sign up for all, share it with your friends. They will thank you. Be sure to read every week in the Fed Zone. That's fed-zone.com. And don't forget to sign up for that weekly serving. It's going to come right to your inbox. So for Ed, the crew at Serving This Serve, and me, Dan Sipe, I'm signing off as I always do by saying, good luck, Godspeed, and above all, remember, it's your Fed life. Make it a great one, because you deserve it. Stay well, everyone. We are out.
Thank you for listening to the FedLife podcast. Click the subscribe button below to be notified when new episodes become available. The information covered and posted represents the views and opinions of the guest and does not necessarily represent the views or opinions of Serving Those Who Serve or Raymond James. The content has been made available for informational and educational purposes only. The content is not intended to be a substitute for professional investing advice. Always seek the advice of your financial advisor or other qualified financial service provider with any questions you may have regarding your investment planning. Securities offered through Raymond James Financial Services Incorporated, member FINRA SIPC. Investment advisory services offered through Raymond James Financial Services Advisors Incorporated. Serving Those Who Serve is not a registered broker-dealer and is independent of Raymond James Financial Services.
Raymond James is not affiliated and does not endorse the opinions or services of any of the quoted professionals or their respective firms. Any opinions are those of Dan Sipe and not necessarily those of RJFS or Raymond James. This case study is for illustrative purposes only. Individual cases will vary. Raymond James is not affiliated with and does not endorse the opinions or services of the quoted professionals or their respective organizations.
Neither Raymond James Financial Services nor any Raymond James financial advisor renders advice on tax issues. These matters should be discussed with the appropriate professional. Investing involves risk, and you may incur a profit or loss regardless of strategy selected, including diversification and asset allocation.